Good afternoon, everyone. Thank you for joining us for this webinar in the Employment Group Spring Sessions. My name is Gillian.
And my name is Karolina Zielinska.
And tonight we're going to be talking to you about Mind the Gap. If you're not on the list, you're not getting in. And what we want to look at today is really to look at the list of protected characteristics under the Equality Act to see whether there's any scope for amending the same or adding to them, and look at some likely candidates that have been suggested over the time. So before we go any further, in case, because I'll get into trouble if I don't mention a few things. So first, to let you know that unfortunately, the recording of this session will be available on our YouTube session for perpetuity. And if you have any questions that you are dying to ask, please put them in the Q&A and we'll see if we have time to answer those. I'm afraid if we don't get time to answer those, they may have to remain one of the great mysteries of our time, or we might be able to answer them by email if we have time. I'm also reminded that, as I said, this is part of our spring series of webinars. So we've got another exciting one, which I think is taking place on the 19th of March, and that's by the two Alexes.
Yes.
And that's going to be about schedule of losses and lots of helpful tips about how to sort out those schedules of losses and strategies for the same. So without further ado, if you're not on the list, you're not getting in. Karolina, I thought I'd just start with saying why I thought that this was going to be a good topic for us to have a look at. As I said, we know that the Equality Act came in October 2010, so it is basically a grumpy teenager now. It's nearly 15 years old. Yes, it's staying out late at night and sleeping in during the day. But one thing that, although we have had lots of changes over the time by case law and some amendments, one thing that's not changed has been Section 4 and the list of protected characteristics. And of course, they're hugely important because they're the coat hooks, aren't they, for us all, for all of the claims that you've got under the Equality Act and anti-discrimination. Yeah. If you can't establish one of those, you're not getting in. So that's why I thought this title is a good one. So if you're not on the list, you're not getting in. I said, it's been nearly 15 years now, and we have the same list of protected characteristics. Karolina, you've got the slides in front of you, so I could do your pop test. How many protected characteristics are on there, Karolina?
9, I believe, she says, counting to check.
So that would be age, disability, gender reassignment, marriage and civil partnership, pregnancy, maternity, race, religion or belief, sex and sexual orientation.
Yes. Yeah. And I mean, I think the analogy there of a grumpy teenager is quite good in showing that whilst perhaps society has developed around the Act itself has not necessarily gone through quite as much change. So I can see that you've given us a nice helpful summary there on the slide of the PowerPoint as to the problems that's caused. Why don't you take us through perhaps some of those in a little bit more detail?
Yeah, and asking the question, because obviously I'm very down with kids. So does Section 4 on that list of protected characteristics need a glow up? And I think the answer is it probably certainly needs to have a look in the mirror because it hasn't changed since 2010. So legally, Section 14, so the combined discrimination, dual discrimination, that's not come in. So that change didn't happen. There isn't a hierarchy of protected characteristics, and I cannot stress that as a discrimination lawyer more strongly. And I'm sure those watching also sigh heavily when they see suggestions to the otherwise. So all of those 9 characteristics, they matter exactly the same. There is no protected characteristic that's got greater weight than the other. And as you mentioned earlier, Karolina, there have been changes over the last 15 years. We're not in the same society in many ways than we were when the Equality Act came in. So I do think it's time for us to consider, should Section 4 have a glow up? And if so, what?
So if we start then perhaps with an outline of what sorts of heads of future protected characteristics could be appropriate.
Yeah, I'm going to look at 2 first of all, because they're 2 that are close to my own heart. So obesity and also menopause. So minding the gap. Is one of the gaps obesity? I'm certainly going to suggest that it's potentially one of the gaps that needs to be looked at. And it was one of the protected characteristics candidates that has been suggested over the years. And time has not, as it were, dulled that argument, because as of today, we are in society where obesity is still, as it were, on the rise. It is, and pardon the pun, an expanding and increasing problem. And I think it was a couple of weeks ago, the Lancet published some interesting research showing that for the first time in a very, very long time, essentially in the last last century or so, we now have hit a time when we are reducing life expectancy rather than increasing. So, and that research showed that one of the main purposes, one of the main reasons, and this was the case, was because an increasing obesity level. So that was leading to high risks of heart disease, cancer, and that largely resulted from poor diets. And this was across Europe, so it's not just us, but yay us, we are among the worst in Europe. I think it was us and it was Greece, which I think when it comes down to the diet, I still find it a little bit surprising that Greece is on the naughty step.
You would have thought with the Mediterranean diet that perhaps that might not be as great a factor in Greece's medical concerns, but there we are.
Yeah. So the stark statistic for me, which I think really throws this problem into relief for today, is that between 1993 to 2022, obesity has doubled, and that is not a pun. It's now 29% of the population are classified as obese in England and Wales.
So such a protected characteristic would be very expansive in the sense it could apply to quite a significant proportion of the population.
Yeah. And indeed, as I saw in the BBC News today, that they were, again, more research has suggested that by 2050, so not that, say within our lifetime, 50% of the population would fall within definition of obese. In other words, obese as far as BMI is concerned. So yes, you can certainly see that it's got potential to be very relevant to again, forgive the pun, a large section of society. And that leads me on to the third bullet point that I've raised, fat shaming. It still is it seems to be one of the last vestiges where it's socially acceptable. And I say that because we look at the negative impact that social media has, tabloids have, and even music, arts, etc. And I think for myself, and again, I know I'm showing my age on this, but I always remember the Blur song back in the days, Park Life, talking about, gut lord marching, cut down on the pies, increase the exercise, So it definitely appears to be an acceptance, but it certainly seems to be more of it's okay to comment on someone's weight rather than you wouldn't comment necessarily on someone's age, their sex, or their race. So is weight discrimination a thing, Karolina? What do you think?
Well, I would certainly say that everybody can think of either an internalized or externalized negative comment that they've heard about or related to weight in their lifetimes. And I think even just one is possibly a gross underestimation of how many people hear in day-to-day life. So clearly, the possibility, the foundation for an obesity-related discrimination claim is there. I think the difficulty, perhaps in my consideration of this topic, is what you touched on earlier, Jill, that this could apply to a really significant proportion of the population. And part of the purpose of equalities law is to protect marginalized groups, yes, but particularly vulnerable groups or smaller groups within society. And I suppose if we reach a point where actually these sorts of protections could apply to a much wider range of people, is that still the purpose for which they were originally intended?
And I think also having a look at the last bullet point I wanted to mention, too high a price. I'm going to have a look in a moment as to where obesity has been argued in relation to disability. Because if disability applies, then you've got the duty to make reasonable adjustments. And that, again, potentially, if there is a large section of society this could apply to, is going to have a very hefty price tag, isn't it? Because we think about the shifts that there have been in relation to sizes over the years, and the fact that as of today, says 29% is said to be obese. We know that means that seats are often complained about as too small. So seats on trains, planes, theatres, duty to make adjustments to those. Duty to make adjustments to people home working.
Yes.
Additional prices of equipment that could cost. uniforms, you can certainly see that the impact, and again, triangle funds, is potentially huge.
It is, and I think particularly in the context of other equalities claims, such as equal pay claims, where we have seen they've bankrupted councils across the country. If this has the potential to do the same or similar, then that is a real factor against it becoming a protected characteristic.
And I'm going to argue, and I said that I don't think we need it to be a protected characteristic, because I think it's comfortably covered where appropriate in relation to disability. And let's of course just remind ourselves about disability. So we have to have, I know I'm literally teacher looking down the camera saying, I know you guys know this, but let's remind ourselves. So physical or mental impairment, it has to have a substantial and long-term adverse effect on the person's ability to carry out normal day-to-day activities. It has to be long-term, so likely to last for 12 months or more, and substantial means more than merely trivial. So on the face of it, obesity, obviously we know that obesity can be contributory to a wide range of health issues. So from physical impairments, ability to mobilize, other conditions, health conditions such as type 2 diabetes, for example.
Yes.
So you can certainly see that there is a potential for obesity in the right place, on the right facts, to meet the definition of disability, but that doesn't mean that it should be a protected characteristic in itself. And I think, again, hats off to the employment tribunal system, because I think we've actually covered this and dealt with it on a fairly sensible basis. As we will also all be aware of, it's not necessary in a disability case to show that the impairment is caused by a particular diagnosis. Think of the Ministry of Defence and Hay case. You have to focus on what a person can and cannot do. That's the relevant test. And in the case of Walker and Sighter that I have put on the slides, Mr. Justice Langstaff, as always, been very sensible, held that obesity in itself did not render a person disabled, but depending on the impacts on day-to-day activities, it might make a person more likely to meet the definition, but it wasn't the obesity itself.
I think, playing devil's advocate, that fits quite well with what many campaigners in the obesity sphere have been saying, to the extent that obesity is not always, depending on who you are and your health background, not always as much of a problem for some individuals as it is for others. And it seems the courts have taken that approach too.
Yeah, exactly. So Mr. Walker, as I recall, had a constellation of symptoms. So he had a whole combination that didn't have a recognisable cause of itself. So here's some functional overlay. He was also obese. He weighed about 22 stone, I think. And the judge in that case had erred, because what he had focused on was the diagnosis and the cause rather than the effects. And so again, it's the stuff really of first principles, isn't it?
Yes.
So the president said in that case that the tribunal should have concentrated on looking at what the individual could or couldn't do, rather than the fact there was a recognised cause. In this case, obesity was the overlay. So that's where we started from. And then we had the case of Kaltoff, which was 10 years ago now, got everybody very excited. I know you missed this in practice, but at the time I got very excited. I was like, oh, an expanding area of employment law here. And so case of Kaltoff. So Mr. Kaltoff, he was actually a childminder. He was employed by the local authority. He was obese. And at the time of dismissal, I think he weighed about 160 kilograms. So that's 25 stone in old money. He was hired to take care of other people's children in their own homes, but had difficulty doing that because of his size. He was provided with financial assistance to attend fitness and training sessions and pay for the gym, etc.
It's quite an interesting feature of the factual background.
Yeah,
one wouldn't normally expect that, but
although his obesity was discussed during the process, he says he was dismissed because of his obesity. The local authorities say no, he was dismissed because of the decline in the number of children. So there was an argument there. But so a number of the questions were looked at, and the Advocate General at the time gave a very interesting opinion was that there's no general principle that obesity would amount to discrimination as a self-standing, as it were. But he opined that certain levels of obesity might. And he actually threw in, he said, if somebody's got a BMI of over 40, that's likely to make somebody disabled. And what he did say was, although there's no general principle, if the worker is hindered in their effective participation in professional life, then that's more likely to make something discriminatory. So when it came to the full decision, the court didn't adopt the over 40 plus, over 40 BMI, but it did say that although there's no need to add that obesity itself wasn't perceived, wasn't discrimination and disability, they did pick up on the point, saying again, and they endorsed the approach that if a worker was hindered from effectively participating in professional life, then it could amount to disability.
So coming back to that substantial adverse effect on daily life.
Yeah, exactly. So I got very excited at the time, and I thought, oh, this is going to be really exciting.
We're going to have change in employment law.
We're going to have loads and loads of these cases. But I said, I looked at my notes on that and looked up the case law since, and there really hasn't been. So excitement was a little bit premature in relation to that. Slight intermission. So I wanted to talk to you about the case of Galvani, which is interesting because it's both an obesity and a menopause case. It's a sex and age case. It's in a pub, so don't worry to the more tender viewers out there. There's not going to be any outrageous language or anything. But this was a pub worker who felt that she wasn't. She was going perimenopausal. She felt that she wasn't being given the same access to the evening shifts as her co-workers. So she asked her line manager, the pub owner, essentially, am I not getting the evening shifts because I'm too fat? And her line manager, I suppose you probably describe him in a tribunal judgment as, he gave genuine and robust evidence and said, yes.
Candid, at least.
Yes, candid, honest, possibly too honest. So you might think that that potentially set up a problem, but the tribunal said no, and they looked at it. They looked at the whether there was any some sort of conscious or subconscious, unconscious bias on behalf of the line manager as a result of that comment, and looking at people who were allocated the evening shifts. And I assume the reason one suspects that evening shifts was an issue is because they'd like to be the more busy times for a pub.
Yes.
And basically turned out that the staff who were working, they were staff of both sexes, and the staff themselves were, and they're described as, get that, slightly overweight. Both members of both sexes were slightly overweight. So on that basis, the claim that essentially that obesity was a factor didn't really come into it. And likewise, age and sex also didn't come into it.
I think that's quite interesting because it shows that essentially the existing protected characteristics didn't serve the claimant in that case. But also, when you give that description of what was said and what the response was, most people would perceive that as quite an offensive thing to say. So really, we have there something offensive being said in the workplace where there isn't really a remedy for it in those particular circumstances.
No, and it doesn't seem to have been pleaded as harassment from what I can see, because to me that feels a bit more like a harassment claim.
So maybe that was the missed opportunity rather than having it as a protected characteristic.
Yeah. So despite my initial excitement about obesity being a disability back 10 years ago, which has slightly petered out over the time, I'm afraid, I don't think we need to add obesity to the list of protected characteristics. I think it's covered on what we've got for disability. I don't think it would be right for it to be added to standalone. So for me, Section 4 is not going to get the glow up in relation to obesity being added to it. Do you agree?
I think I'm largely on the same page with you there. I think the financial argument there is quite a strong one, that the cost of including obesity as a protected characteristic may well be too significant, particularly given how many people are likely to fall within a definition were one to be created of that sort of protected characteristic. I just think that might render it unworkable in practice. But with that, let's consider another protected characteristic that might be worthy of a glow up.
Yeah, again, one that's becoming more and more close to my heart, literally, as the years roll by. Menopause. This has obviously been something that has been very much talked about these days. And it's topical, and I'm glad it's topical. And I would also just like to, when I say topical, big up and please go to 42BR and our YouTube site, YouTube channel, because we had a fascinating annual lecture on this. So please do. If you haven't watched it, please watch it, because it's fascinating. A little bit scary sometimes, but it's a fascinating both medical and legal look at the impact that menopause can have in the workplace. So, yes, so very, very topical. And I like to think 42BR, as always, being very topical. So please have a look at that. Why do I think that menopause is a good candidate? Well, partly because the House of Commons told me so. Their recommendation is that the government consider that menopause be added to the list of protected characteristics. But let's just take a step back and think why that might be the case. So it's talked about a lot, so I won't go into too much detail, but potential symptoms for perimenopause do immediately start to set off some alarm bells when you look at them.
As a young woman reading that list, I'm slightly concerned for the future, but I appreciate how much those can impact people's day-to-day life.
Yeah, so I mean, just looking at that list, so on average, women are going to go into perimenopause between about 45 to 55. Average age for the menopause, so 12 months and no periods, 51. Symptoms can last from a few months to several years. So immediately you start to think about the definition of Section 6 being met in any event. But looking at that, so we've got low mood, we've got anxiety, depression, we've got fatigue, we've got poor concentration, heavy periods, anemia, heart palpitations, difficulty sleeping, hot flushes, sweating, muscle pain, joint pain, increased risk of osteoporosis, vulnerability increasing to heart attacks and strokes. Looking at that list alone and just talking through that, you can feel the potential disability claim coming out of that.
Absolutely.
Yeah. The most widely reported symptoms, as I've noted on the slide, are difficulty sleeping, concentration and memory issues, hot flushes and light sweats and anxiety. I've included on this slide the wonderful Davina McCall, because I think she's been a real champion. Great. She's enabled this topic not just to come out of the closet, as it were, but to be talked about openly now. So that we have, World Menopause Day, etc., which is great to see. So it's nice to see this being portrayed in a more positive light. But I really want to focus on why it matters for workplaces. And I think really that penultimate bullet point that I put on the slide, I hope people can see, will really give you a flavour of why. So the Bupa research that was carried out, so approximately 900,000 women have had to give up their jobs.
That's incredibly shocking to see. And you're right, it speaks to why it's so important in the workplace to at least make accommodation where necessary for people suffering with those symptoms.
Yeah, and as I said, the report also goes on to show that women who suffer from one or more problematic menopausal symptoms, because I'm not suggesting that every woman will have problematic levels of menopausal symptoms, but 43% are likely to have left their jobs by the age of 55. 23% are likely to have had to cut down their hours because of it. So, but as I said, the shocking statistic is that we have lost almost 1 million women from the workplace. I mean, that's a brain drain at a time when women should be at the top of the game.
Yes, absolutely. I mean, your earning potential is higher. You're at a greater stage of your career at that point. It's incredibly sad to see a statistic like that.
Exactly. So immediately we can see that that's going to have an impact on whether you're a respondent or your claimant, basically. And indeed, it's one of those areas that, despite great work that has been done, it seems to me, Karolina, and I think, except as even as a younger woman, there's still an element of social stigma attached to it. People still do not like talking about it, although there have been more conversations over the last few years. Yes. So I would just endorse what the House of Commons said in their report. Say that menopause is a workplace issue. the House of Commons report was said as following. It says, menopause is a workplace issue. There is a legal, economic and social imperative to address the needs of menopausal employees. We are not persuaded that a legal requirement for every workplace to have a menopause policy would embed meaningful change. But there is much that employers can and should do to help their employees. Many of the solutions involve practical adjustments, and in allowing additional flexibility and understanding alongside fostering a greater respect and understanding of the menopause. Employers who fail to support their menopausal employees or act punitively towards them leave themselves vulnerable in discrimination claims. They also risk their reputation, their ability to attract and retain female talent, and their profitability. So the House of Commons report clearly recognised that there was significant issues. What they did recognise, Karolina, I'm sure you picked up on that, is that it said leave themselves vulnerable to discrimination claims.
Absolutely.
So that leads me to the question. I said I could talk for a lot longer on menopause, but because we're going to get some other interesting questions as well, I won't do that for too long. But really to ask ourselves at this point, again, in relation to my glow up of section 4, is it necessary? It seems to me that if you added menopause as protected characteristics in your own, it would have some pros. It would clearly simplify claims. We wouldn't have to be trying to shoehorn claims into another protected characteristic. So at the moment, you have to look at age and sex, and let's bear in mind that at the moment there is no combined discrimination.
It really does feel like one of those topics that would benefit from a provisional combined discrimination more than others. It's so inherently related to both of those that
it is, because all women are going to go through it,
yes,
but not necessarily all women are going to have it to a degree that causes problematic. It is age related. But so, yeah,
it just feels artificial to separate it out.
It does feel
necessary under the current provisions.
But so the recommendations were indeed they said that menopause should be join the list of protected characteristics, and also there should be a duty to make reasonable adjustments. And I think this actually is the case. Had the duty to make reasonable adjustments applied, it seems to me that unlike obesity, it's not a massively onerous thing, is it? Because what do you need? You need greater flexibility. You need perhaps, if there is absences, for those absences not to be recorded as sickness and to be dealt with a bit like disability related. You might need to have adjustments made in relation to uniforms, temperatures. It's not going to cost a lot. Those sort of adjustments, it seems to me.
Yes, it seems as if you're saying really that the adjustments are already in practice for other reasons. They're just repurposed as menopausal adjustments.
And as I say in the second point of the slide, certainly would reduce the stigma. You wouldn't, if employees have a protected characteristic to hang their claim onto, they don't need to try and shoehorn it into others, and would also reduce the societal stigma of bringing a claim about it, because it'd be recognised, well, this is something that you can bring a claim about because it's one of the protected characteristics.
Absolutely, yeah. Well, it's been an interesting overview, I think, of the menopause there. But
but do we think it's necessary? Because
I'm erring on the side of no after hearing your arguments. I think that it does seem to me that whilst there's benefit in having more conversations about the menopause generally, particularly in workplaces, I do think it's adequately covered by the existing law.
And I think one of the reasons that you're right on that, Karolina, is whereas a few years ago there weren't so many cases, there are now more cases, and there have been more successful cases. So I think that sort of answers the point: do we need to have it in? Lots of people would actually say, please don't, put it in because this is a natural life stage. Please do not medicalize, do not stigmatize that of itself. And indeed it is covered by other protected characteristics, so age, sex and disability being the obvious ones. So let's just have a very quick look, and because this is not just all about menopause, I will just deal with these very quickly. So we've got a couple of EAT cases now. The Rooney case, the social worker case, in which it was held that the tribunal gave insufficient reasons. So in other words, that they didn't look properly at whether her menopausal symptoms amounted to a disability. In relation to update on that, so that was successful on appeal. And when you look at the facts, it's easy to understand why. Just really by way of an update, so you and I both looked, it obviously went back to tribunal in October 23. I can't see a judgment, so I don't know if it's settled or what has happened to that case. So, I think you agree with
Suspect
that.
it settled.
Yeah, it may have settled. I don't know. If anybody knows the answer to that, please do let me know. But the facts on that were sort of case one that I just wanted to highlight a little bit, because it surprised me that this did not get held to be a disability by the judge. So claimant was, as a social worker, she was bringing various claims of disability, including direct disability claims and constructive unfair dismissal. She was taking HRT. She was under the care of a menopause clinic and a consultant. She suffered from hot flushes, palpitations, night sweats, sleep disturbance, fatigue, poor concentration, urinary problems, headaches. So a whole range
Quite
of
frankly,
issues.
that seems like the gamut of menopause symptoms. I'm quite surprised that didn't necessarily meet the threshold.
And also the symptoms. So in her impact statement and her evidence, she said, she would forget to attend events, she would forget to attend meetings and appointments, she would lose personal possessions. And I think she even said that on some occasions she forgot to put the handbrake on the car, lock the car. She left the iron on, the cooker on, those sorts of things. So she was also a carer of her husband and her mother. Again, this is the thing about the age discrimination claims. This is often a time in life when women have additional caring responsibilities. And where the tribunal fell into error, I said these symptoms were, by the way, for approximately, I think, over a 2-year period, was that the employment judge focused on what she could do, i.e. that she was a carer for her husband and her mother, not on what she was struggling with and the coping mechanisms. So it's really, that's really where it went a bit wrong. But I don't know what's actually happened with that case, other than it was appears to have started in October 23. And then the other case that was unsuccessful on appeal was Gallagher and Labello, and that was really unsuccessful because it's, in terms of the menopause, it's whether the employer had constructive or actual knowledge of the level of disability, indeed that she didn't really like talking about it. So
it turned on that, really.
Yeah, it turned on the facts. So both of those are cases that show that application of basic disability provisions has been sufficient.
We do have one final question, I think, that's come up about the menopause issue.
Okay.
I'll put this to you. I think it's good to talk about.
Yeah.
The question is, would the floodgates or cost argument also apply to the menopause? And how would you confirm a woman is indeed menopausal?
But again, I think that's first principles, because it's the same as in relation to any disability, wouldn't it? You would probably, as an employee, probably still want some occupational health input, but it's disability impact, isn't it? It's about describing that these are the symptoms that I'm having.
Yes.
This is the impact.
Yes.
And on the floodgates and the costs, I don't think, or my feeling is that these are not expensive adjustments. So
well, as we discussed earlier, a lot of them might well be adjustments that would be made regularly anyway by a larger employer. So I think on that point, the cost is less likely to be significant compared to obesity-related adjustments, which might be more novel. And also potentially, to be fair, obesity, if we're in 2050, is saying that 50% of the population. By then, perhaps the novel argument doesn't apply.
In relation to menopause, there's 50% of the population, but it's not a case that 50% of women of perimenopausal age will be having problematic symptoms. Yes, that's not the case. Still a smaller category. It's a smaller category within there that's going to require those adjustments. And I appreciate that it is difficult with menopausal symptoms because they can fluctuate. So there might be times when different adjustments are required. There might be times when adjustments aren't required. But it doesn't mean that conversation shouldn't be had between employer and employee. And I suppose that is where there is some benefit, as I'm not a great fan of paper. I don't see having a policy for policy's sake really helps. What actually makes the difference is adjustments. And I don't actually think you need to add menopause to the list of protected characteristics to have that conversation and to make those adjustments, because disability already provides us with a duty. And also it seems to me protects the employer because it's in the relevant case, it's the right case, i.e. where it's going to meet the level. So I've just put the string of cases that we now have up in relation to those are tribunal cases, first level. So again, that seems to suggest to me that these claims are now getting through. I seem to remember reading in the statistics that there's been like a 40% increase when menopause is mentioned as part of the primary facts and potential claims. So it seems to me that Davina effect has had the Davina effect has indeed had an effect. So I'm going to argue, although I'm very strongly in favour of this as an area that I greatly appreciate that there's been more conversations on, I don't think Section 4 needs to glow up in relation to menopause.
I do think I'm with you on that one, Jill. So with that, let's see what other sorts of potential protected characteristics we could add to our list that require glow ups. First, I'd like to talk about class. I think that, yes, I think that's the correct response. Really, when canvassing this with my colleagues, the main issue with the potential of class as a protected characteristic seems to be how one defines class. Because quite frankly, it's a very flexible concept that I think doesn't even have, well, has national boundaries. It's going to be different country to country, let alone town to town. People's perception is going to be quite individualistic of this. I've included on this slide a definition of class. That's the Cambridge Dictionary, a group of people within society who have the same economic and social position. So social position is quite wide, but at least I think with economic position, we could perhaps narrow that down a bit. Now, in terms of how the law already addresses economic position, I've again set out Section 1 of the Equality Act 2010. Now, this is the public sector duty regarding socioeconomic inequalities. Of course, has not been brought into force in England yet, but has been in force in Scotland as of 2018 and in Wales as of 2021. And I think it's important to note that at the outset, because we have seen in other countries that it does work. It can work in practice, but England has not yet followed that lead. In terms of what it actually states, just a recap for those listening, the public sector duty is, of course, that when an authority is making decisions of a strategic nature about how to exercise its functions, it has to have due regard to the desirability of exercising them in a way that's designed to reduce the inequalities of outcome resulting from socioeconomic disadvantage. So in essence, when making decisions, a local authority has to think about the impact of its decisions on people who are socioeconomically disadvantaged.
And excuse me, Karolina, that's got to be something that's become more relevant, hasn't it? Particularly since the pandemic.
Absolutely. So if this were introduced, what sorts of changes do you think one might have seen during the pandemic in the way that authorities approach the issues?
Well, I think, and I'm sure if there are any local authority solicitors online, they would agree anyway, but I think it had a huge impact anyway, because the authorities found themselves having to provide services, having to have employees all from home.
Yes.
And that's, as far as economic and social position, that became a real issue, didn't it, Karolina?
So access to technology is a big divider there in terms of the cost of it. And a family who perhaps shares a laptop may well have found the pandemic much more difficult to manage when working from home and schooling from home than a family that had more tech available. So there may well have been a necessity on council's part to provide that sort of technology had this been enforced in England during the pandemic.
I've had a few cases where exactly that in tribunal, where local authorities suddenly found themselves thrust into a position where, and to be fair, authorities have done a fantastic job with the resources that they had.
Absolutely.
Suddenly they had a whole population, their employees were working at home, and obviously those employees often had caring responsibilities. And indeed, I have a few cases where that was exactly the position, and they did find themselves having to try and get laptops, and were, and did a brilliant job of trying to do that. But it's everybody at the same time.
Yes.
So that's just looking at the provision of equipment. But when we think about it, I'm guessing as well that reality may well have had a knock-on effect on performance.
Oh, absolutely, yes. And really, that's what this sort of legislation is designed to minimise impact as a result of disadvantage experienced both in the workplace or in any other sort of public context. Education here, I think, would be the big one during the pandemic. But yes, and I think, since we've touched on definitional issues, I think everyone can agree that's clearly the problem with class as a protected characteristic. I think another facet of that is that people aren't necessarily as willing to stick their head above the parapet and say, I am of X class, as one might think.
But isn't that exactly it? So if you're in the pub or you're having dinner, party conversation, you might not perceive yourself to be of a certain class.
I think people might be very happy to say I'm proudly working class, or I'm middle class, but
But I
perhaps.
might not agree with you. I might think,
Oh, look, precisely. Perception is going to be very different. And then also when we start defining it by reference to socioeconomic status, it doesn't sound quite as good to say I'm in poverty, does it? Then,
no.
So I think there is going to be stigma attached to many of those labels. And that's something that might have a chilling effect on claimants looking to bring those sorts of claims.
And surely isn't that going to be the biggest difficulty is if we as individuals can't necessarily agree
Yes.
what our class is, how is that going to be successfully defined to add to the list of protected characteristics?
Absolutely. I think it's easier to recognise class-based discrimination than it is to really drill down into why it's class-based discrimination. It's that sort of recognizing an elephant when you see it, but not necessarily being able to describe it in a way that everyone would recognize.
Knowing that many of our prime ministers have come from Eton, but not necessarily.
I do wonder actually whether one could say there's some sort of socioeconomic duty to force those in government to be of a certain percentage, different backgrounds. I mean, we're talking positive discrimination now here, but it's interesting to think about what kind of impact that could have. So I think before perhaps I ask for your overall view on class as a potential protected characteristic, we should go on to consider caste as well, because they have, I think, very similar foundations. Class might be what we recognise more readily in the Western world, but certainly caste is a concept found in various religions and cultures. It's not confined just to one or two, as one might initially think. It can be found in all walks of life, from Hinduism to Christianity. And based on the definitions I've seen of caste, it seems to refer primarily to religious status or occupation, but can also be linked to your friendship or family or kinship group, to put that in the widest possible term, that you're associated with or part of. So it's got those socio and economic links, but perhaps with more of a focus on occupation and your familial background. Now, with caste, presumed caste, as with presumed class, is often equally as important. So people might think that you're from a particular caste if you're known to have a particular profession, or if you're known to have a particular surname or associating with a person. So again, we have that issue of definition versus people perceiving as actually being the stronger part of what discrimination is actually faced in practice.
But as we know, with other protected characteristics, that works. I mean, you can have associative discrimination, you can have perception.
It's not a barrier.
Yeah, it's not a barrier. So I don't think that's a problem. And of course, caste is the one that was originally, go back 10 years, 15 years ago. I mean, it's in there, isn't it? It's in the Equality Act.
Absolutely.
It just hasn't come into effect.
So Section 9(5) of the Equality Act 2010 was amended by the Enterprise and Regulatory Reform Act 2013, so that it does read: a Minister of the Crown must, by order, apologies, it was may before, to amend the Act to provide for caste to be an aspect of race. Plainly, that's not been done yet.
And it's not been done in 15, but I say in 15 years, because that's obviously when the Act came in, but it's been much talked about, but it's not come in. Why do you think that is?
I think in practice it is because case law has already effectively allowed for caste to be part of the Equality Act race definition.
Okay.
So in the case of Chantok in Turkey, which is cited on the screen there, essentially it was confirmed that Section 9(1)(c), so that race includes ethnic or national origins, that was broad enough to protect victims of caste-based discrimination. And in that case, the claimant was born in Eastern India and was a member of the Adivasi family, who were commonly treated as people of a lower caste, so servants in context. And she worked as a nanny in the UK, but was not, during her employment, paid her salary. She was working 7 days a week with no daily or weekly breaks, and her working environment was, quite frankly, a violation of her dignity, in the words of the Employment Tribunal. So there, in terms of the factual background, we can see quite a stereotypical idea of what one might think of as caste-based discrimination. Now, there, I think there were very strong ties with the claimant's ethnic origins. But it is interesting to think about cases that might not fall within those provisions. So, for example, where it's entirely based, the discrimination is entirely based on your occupation with zero links to ethnic or national origins, that may well fall outside of this expansive definition of race, so it wouldn't be protected by the current law. So whilst we have some recognition of the ethnic side of caste, we don't necessarily have recognition of that broader socioeconomic discrimination.
Okay. But as I said, it's obviously a tough one because it's not come in, and there are no signs of it, certainly not been suggested anything in the Employment Rights Bill that's going to do anything to caste. So it seems to be it's going to just stay there as one of those ones that might come in.
Yes,
it's a bit too difficult.
Section 1 of the Equality Act, this provision, who's to say if it will ever come into force? So I think, again, a watch and wait on this one, but certainly I think very compelling arguments that it ought to be a protected characteristic, given that it has already been recognised in part as falling within the definition of race discrimination. Yes,
because the interesting thing about caste, isn't it, that I appreciate that in Chandok and Turkey they recognised it could fall under race and ethnic and national origins, but it's more nuanced, isn't it? That's the thing. That's by bringing in caste, you would deal with that, the fact that it's the more nuanced element about caste rather than ethnic or national origins.
I think it is wider than that, and the current law just doesn't quite recognise that insofar as it talks about race.
So might we be concluding then that although we don't think necessarily on relation to caste that Section 4 needs a glow up, they could perhaps brush it up and bring in what they said that they were going to do?
Absolutely. And I think it's interesting to see the overlap between the definitions of class and caste, because effectively definition on the basis of caste might be class by the back door.
No, I'm not with you on that. I think class, for me, I still think that class is too nebulous. Until we can all agree on a definition of class, I just cannot see that makes a workable protected characteristic.
Well, let's come on next then to our final potential protected characteristic, that of being a care leaver. Now, I think that this is potentially, for me, the one that has legs out of all the protected characteristics we've discussed today. I think this has the most compelling arguments for being recognised as one.
Why is that, Karolina?
So at the moment, we have quite wide-ranging duties imposed on the government to support those who have previously been in care. I've cited there Section 3 of the Children and Social Work Act 2017, which requires local authorities to provide personal advisors to care leavers, and that's defined as those leaving foster or local authority care.
So that's from the age of, I think it's rather brutal cut-off, isn't it?
It's 25. Okay. So it's actually quite expansive in that it's intended to support you in that period of life where you're a young adult and might otherwise be receiving substantial help from a family, such as still living in the family home, but don't necessarily have that availability in the circumstances. The local authority is there to act as your parent, and hence the slightly more onerous duty. So the support's there. There's a recognised need that this section of society is going to be vulnerable and require additional support.
Does that make sense? Because you wouldn't necessarily kick your child out at 18.
Yeah, and what I found really interesting about this is that the support offered is incredibly wide-ranging. Councils are required to publish a list of advice, support and guidance available to care leavers in their area. It's called the Local Offer for Care Leavers. And just to give you an idea of the kinds of areas where the government envisions there will be disadvantage, the sorts of things that tend to be included in that local offer are, of course, careers information and advice, help buying things for work and education, so outfits if necessary for particular careers, books and essential clothing, help with travel costs, help with access to health appointments, help with being a parent, opening a bank account, driving lessons, obtaining a passport. I mean, quite frankly, it's incredibly expansive in scope in terms of the support offered. So again, really that ultimately shows that the disadvantage can be material and affect so many different areas of your life.
But Karolina, the reason that you've given quite a long list there of areas, and again, those of us, the parents, would recognise that as sort of, or the support maybe we had from our parents if we were lucky. It must follow, mustn't it, therefore, that there has been a difference of results or attainment for people who've left care?
Absolutely, and that's reflected in the statistics, and hence why there is, I suppose, that greater need to protect the more vulnerable in society. The reason that I say that there is a particularly strong and compelling reason to introduce this as a protected characteristic is because definitionally there's less of an argument. Whilst one might argue over the specifics, such as whether or not adopted children ought to be included in that provision, and bearing in mind that they have something more of a stereotypical family unit that could provide those types of support that I've listed, really most people would be happy to accept that this includes people who have previously been in foster or local authority care. But importantly, and I've not seen this really in any other sort of area with different protected characteristics, but many local councils across England and Wales are starting to pass local motions that care leaver be introduced as a local protected characteristic. So they'll effectively update their own equality impact assessment forms for their own use within the borough to include this as a consideration, even though it's not legally required. And then if claims are brought for a breach of the public sector equality duty, presumably that could potentially be relied on, even if it's not part of the Equality Act, although it might have to be formulated slightly differently in terms of the way the claim is put. But an avenue for recourse, even though it's not part of the Equality Act 2010.
So it seems to me that what we're saying here is that we can identify a group of people who have different needs, reduced outcomes, and they're easy to identify.
Yes.
It seems to be something that is supported by local authorities and the need is recognised.
Absolutely.
So from what I'm hearing, that sounds like a pretty strong case for making a protected characteristic.
Precisely. My one thought was, I suppose on the converse of that, if the practical impact is that local authorities are having greater regard to this when they're applying a public sector equality duty, maybe what we actually need is not necessarily for this to be added to the list of protected characteristics in the Equality Act, but rather for an equivalent law to the public sector equality duty, but just with reference to care leavers to be implemented. I suppose then the downside would be that that wouldn't give protection in harassment, victimisation, etc. for care leavers, but that might be one more palatable way of doing it if the government's struggling to get enough consensus to amend the Equality Act.
But so by potentially adding as a protected characteristic, of course, that brings in ability to bring all of the claims.
So limiting it just to the PSED, especially if that's where it's applied most regularly, might be a way around having those difficult discussions. But quite frankly, the government has already considered this. And the Children's Commissioner summarised responses to a study, survey on whether or not to introduce this protected characteristic. I found those responses quite interesting. Ultimately, the Commissioner came down on the side of recommending that it ought to be a protected characteristic. But the arguments in favour really were that it brought greater recognition to the issue, and that it could empower people who've experienced that sort of discrimination and trauma. So fairly standard responses in that sense. In terms of the arguments against, they were summarised as resulting in potentially more discrimination and stigmatisation, but I'm not sure on balance how much I'd agree with that. Usually, I think it just by bringing in anti-discrimination prohibitions, we're not saying that experiences in care have to be a negative, or rather we're just trying to eliminate the conduct where people do perceive it as a negative, and are expressing that in a way that's impacting you in the workplace or in education or otherwise. And I think further points were made that really what children in care needed was for the system to be less politicised rather than more, but I think these really are more tangential concerns rather than ones that go to the key issue of whether or not it would be it would help to include this as a protected characteristic.
And that's more looking at remedy, isn't it? Sort of the carrot and stick approach.
Yes.
I understand, obviously, if you put something on the list of protected characteristics, that's going to be more sticky, but that's life.
Yes. So I suppose overall, I'm clearly quite in favour of this becoming a protected characteristic, purely on the basis that councils appear to already be applying it like that, particularly in respect of the public sector equality duty, where they've passed these local motions for it to be recognised. Any thoughts on that, Jill?
Well, I mean, I'm with you on that. You've made good arguments, so you
you.
persuaded me. So stepping back really from our section 4 at the moment and the various potential candidates that we've looked at for the glow up. So we've got 2 that have actually had recommendations. So we've got the menopause,
Yes,
and we've got care leaver. Both have had recommendations. We'll see what happens, I suppose.
yes,
Yeah.
I think it's watch this space, but crucially, I think this is relevant to all the protectory characteristics we've discussed thus far. One of the practical impacts that would be had not just the ability to bring claims in relation to those characteristics, but also the defence in context of discrimination in section 109 would require, if employers wanted to rely on it, that employers educate their employees about the potential impact of these characteristics, how to act in relation to them, and what to do and not to do in the workplace. And I think that really would bring more understanding generally to the workforce about these particular issues. So that is another benefit that applies equally to all of these.
As it has with menopause, for example.
Yes, absolutely.
Well, I think we need to start wrapping up because we've only got 3 minutes and you and I have a meeting to get to after this.
Absolutely.
But Karolina, thanks very much for that. It's been a really interesting
It's
conversation.
been wonderful talking to you, Jill. And I will just again repeat that the recording will be available on the website and the YouTube channel of this talk shortly, and we'd be grateful for feedback. The next webinar in this series will be hosted by Sam Healy and Amy Stroud on Tuesday, the 1st of April. We'll look at how employers and employees can explore settlement of workplace disputes without landing themselves in hot water in any subsequent tribunal proceedings.
And that is not an April Fool's joke. That is happening.
So yes, the next 3 sessions in this series will be released in April. Please keep your eyes peeled for that. Thank you so much for attending today and have a lovely rest of your evening.
Thank you very much for joining us. Goodbye.